Good morning to one and all. Myself Kajol Vajani, and I would be speaking on the topic right to privacy, though fundamental, how feasible and enforceable in today's digital age. A very excellent topic. So I would structure my speech in 4 parts. First, talking about privacy in digital world, then the right to privacy as a fundamental right, then the main question, how feasible and enforceable it is today, and lastly, how it could be protected through more possible ways. So start with, let's imagine you are sitting in a garden near your phone and talking about your dream house. What happens next? You immediately start getting property recommendations to WhatsApp and Facebook ads. Don't you wonder how it happens? Of course, your privacy details have been stolen without your consent. Exactly. That's what I'm talking about. I'm not talking about your bedroom privacy. The concept has evolved much more. I'm talking about we live in an emerging digital era. Of course, digital technology can be a powerful tool for advancing human progress, and it has contributed greatly to the protection and promotion of human rights. But when we talk about privacy in digital world, nothing is private. So what about my right? Of course, we do have a right to privacy, which is recognized as a fundamental right under Article 21. Of course, this was not directly recognized, but has been recognized through judicial advancement in the landmark case of K.S. Puttaswamy in the year 2017. Although it has been recognized as a fundamental right, it is not an absolute right, meaning it comes with its reasonable restrictions and may vary from case to case. Now coming to the main question, how feasible and enforceable in today's digital world. Now talking about the feasibility, we use technology for the sake of necessity and convenience today. So it is not completely possible to not share some basic details also to use the technology. If I ask you, would you be able to go on particular location without sharing your GPS or live location permissions to the map application? The answer is simple no. That's why it's not entirely feasible to have the privacy in today's digital world because of the necessity of we have to use it. Now coming to the question of enforceability. Of course, it is enforceable and it can be more better enforceable. Now first we understand why we need enforceability. So of course, when there is a violation of right to privacy, we need protection. There are n number of cases of violation. Like in recent December itself, Twitter leaked 400 million users' data. Zoom also shared the users' data to third party without their consent. Of course, WhatsApp privacy case we all know. Later on, HIV positive patients also are dropping out of the treatment programs just because of the fear of their data leakages. And the worst comes here. Aadhaar data of 1 billion people is available just for how many rupees? Any guesses? Just 500 rupees. So in all these cases of violation of right to privacy, there is a need of protection and also a responsibility to enforce a regulation to secure this data. Now, if we talk about how much it is presently enforceable, so of course, Indian judiciary has few provisions like Section 43A and 72F Information Technology Act, and also there is a Sensitive Personal Data Bill Rule 2011. But these measures are inadequate. The Indian legal system lacks legislative framework which can ensure data privacy. Now, if we look at the global scenario, there are certain existing regulations like Canadian Parliament's Privacy Commissioner's Guidelines for Online Consent, or there is also Brazil's Internet Bill of Rights. In spite of this global consensus, there is how to best protect this right and enforce this right to privacy is still remain a difficult problem. Because right to privacy comes with its own complexity and more advanced technology demands more advanced laws. It's not that we don't have enough judiciary enforcements right now. Of course, judiciary is advancing. If you take an example, recently in 2021 itself, in the case of Manohar Lal Sharma versus Union of India, Supreme Court held that every citizen of India ought to be protected against violation of right to privacy. We are also awaiting the most awaited bill, that is Data Protection Bill, which was 2018, but of course it can be a better enforcement tool if it gets enacted. So, along with these traditional solutions of enforcing laws, there has to be a technical solutions as well. If I ask you, how many of you know that you can actually go and check where your other details have been used from the UIDAI website itself? Lack of awareness. There's also companies are coming up to contribute there in this problem. Like yesterday itself, Apple launched its awareness efforts wherein they'll educate the users as to how to safeguard their data. So, of course, when we say right to privacy in digital age, it demands more united and a multinational alliance which can ensure that users share an inalienable right. So in the end, I would only conclude by saying that right to privacy in being recognized as a fundamental right to developing a firm jurisprudence over it, the concept of privacy has evolved. And of course, in the present judicial scenario, it is a challenge for the judiciary to protect citizens' right. And when the technology is creating more facets towards right to privacy, the law has to be molded to support this. And Indian state may require an intervention to check on its undisputed power. With this, I would like to end. And I would just like to say that 28th January is celebrated as Data Privacy Day, and it's just a coincidence that we are discussing this important issue here. So I'm looking forward to a better and a secure future for all of us. Thank you so much.